Welcome to Ask a Lawyer with Christine Matus. Attorney Matus is recognized as an authority on special needs estate planning, real estate law, and nonprofit rules and regulations. Join us as Christine answers your questions about the law and how it affects you.
Christine, can a will help a person avoid intestacy laws?
It's a great question, Steve. You know, if you do not use a valid will to describe whom you would like to get your assets, well, then anything you own at the time of your death will automatically go to your heirs, and that is set out by New Jersey law. You know, a lot of times, many people, like myself, we want the freedom to name who should get our assets, and we want to dictate, how much each person can receive. And that is an important aspect of a will. A will can actually help you accomplish that goal.
So can a will allow me to give more to certain folks?
Yes, absolutely. In intestacy laws in New Jersey, they often divide up properties equally among all your heirs. But in your will, that would allow you to craft specific amounts that can go to each person. And interestingly, it also will permit you to exclude people that you do not want to have with regards to your assets, and even if they would have been included under the intestate laws. So that's a very important aspect.
Can I pick who'll administer my estate?
Well, Steve, if you don't have a will, the court will appoint someone to administer your estate. And, oftentimes it's a family member, but it does not have to be. If you have someone special that you have in mind that you'd like to distribute your property, then that needs to be set out in your will in writing.
Okay, well, how about property outside my estate?
Great question. Many people choose to use other types of estate planning tools in addition to a will. And for example, life insurance, trusts, and property held in joint tenancy. So generally speaking, a will does not have any effect on those types of property. You will need to take, additional steps to make sure that these types of properties are provided to correct who it should go to. You can specify the beneficiaries after you pass.
Can it provide funeral or memorial instructions?
Interestingly, and a lot of times we have to think about this, but your will is generally read after your funeral. So that means that putting burial or funeral instructions in this document may not be helpful for your loved ones. You would have to use another method to convey this information to your family and friends. And that's something we do help our clients. We make sure that's included in your estate plan, that separate tool to make sure your family and friends know what your wishes are regarding your funeral and your memorial instructions.
Okay, well, that's good to know. And estate taxes, can it reduce a will? Can it reduce estate taxes?
Only those estate planning tools that decrease the value of estate will help you reduce your estate tax obligations. Interestingly, a will is not one of those devices. A will simply describe how your property should be distributed. It does not remove assets from your estate to avoid taxes. There's other methods, other tools that we have in our toolbox that we can provide to our clients if you want to reduce estate taxes. In general, wills can be extremely useful if used in the right way, Steve. But in many situations, however, it is just one of the many tools that we could offer when we take a look at what your estate plan could be.
Thanks for listening to Ask a Lawyer with Christine Matus. Attorney Matus can be reached at 732-281-0060. Her website is matuslaw.com.